Want to talk about an awkward situation at trial? During the middle of a trial, I turned to my opponent and I said, "Hey, Mr. Jones, can I use your exhibit to ask my witness questions?" And the attorney said, "No, you can't." You want to know why this was so awkward? For him? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, we're in the middle of trial. I now want to go ahead and cross-examine the defense's medical expert. It's a medical malpractice case. And now the defense has called an expert to go ahead and refute and dispute all of our claims. After the defense attorney has finished questioning his own expert, the judge turns to me and says, "Mr. Oginski, you may begin your cross-examination." Great. Now I get up and I begin cross-examining this particular expert. During the course of my questioning, I want to refer to an exhibit, an enlargement, a blow-up of a photograph, an enlargement of a hospital record that this doctor talked about during his questioning when he was being asked questions by his attorney. So now I go over to the corner of the courtroom where the defense lawyer has stored all of his large exhibits. This is something like 30 inches by 40 inches. It's a really large exhibit. I want to grab it and put it up on an easel so that the jury can actually see it while I'm asking the doctor questions. So now, as a courtesy, I turn to my opponent because remember, he paid for these exhibits. He went ahead and prepared them for this particular trial. And now it's really inappropriate and impolite for me simply to grab his exhibit and put it up on the easel so now the jury can see it. So what do? I turn to my opponent and I say, "Hey, Mr. Jones, do you mind if I use your exhibit while I'm questioning your expert?" And he turns around and says, "Yes, I do mind." What? What do you mean you mind? You just used this questioning the doctor. I now have questions I want to ask the doctor about this, and I want the jury to be able to see it. You're really not going to allow me to use your exhibit to question your expert about something that you asked him about and you showed him this particular exhibit? You must be kidding me. An inexperienced attorney might turn to the judge and say, "Judge, he used the exhibit. Why can't I use the exhibit? Can you tell him to please tell me that I can use the exhibit?" No, I don't want to whine in front of the jury. I don't want to whine to the judge. That's ridiculous. So instead, I may do this. I may ridicule the attorney in front of the jury for what he's doing by saying, "You must be kidding. Are you telling me you're not going to allow me to use your own exhibit to question your expert when you already questioned him about this? Is that what you're telling us?" And now he's in an awkward position because if he says no and continues to say no, he looks ridiculous because he was the one who used this particular enlargement of a medical record to ask his own expert questions. And to prevent me from simply pulling it out of the corner and putting it up on the easel, takes no effort to do that. There's no skin off his back to do that. Let me share with you an instance where it would be inconvenient and would be a bit more difficult. Because many records are digitized and scanned, now each attorney has different programs that we can use to go ahead and show the jurors different medical records on an overhead projector or on a computer screen in front of them or in front of the courtroom. And now when that happens, it becomes a bit more difficult if I were to say, "Hey, Mr. Jones, can you pull up page number 363 of the medical record and put it up on the projector so the jury can see it while I'm asking this expert questions?" Now that's a bit more involved, it's a bit more complex, and especially if the attorney is not the one responsible for getting that information in front of the jury and relies on somebody that he hired to do that, who may be in the courtroom or may not be in the courtroom. Now it's a bit more of an imposition for me to ask him to do that. And although it's still awkward for him to answer no, he may feel more comfortable saying no in that instance because it is more difficult to pull that up. But at the same time, I can turn around and say, "Wait a second, you asked your doctor questions about this medical record. I want the jury to see exactly what it is that we're talking about. I don't have access to my computer right now. I don't have access to that page. I don't have an enlargement. Could you do me a favor and pull up page 363? How hard is that?" And now if he's reluctant to do that, the jury might turn around and say, "Hey, wait a second. Why is this defense lawyer doing that? Why isn't he allowing Oginski to go ahead and cross-examine this guy and to show him the photograph or to show him the enlargement or that medical record that he referred to?" In many instances, the defense attorney is going to capitulate and say, fine, go ahead and use the exhibit. Go ahead and use the enlargement. It's in the back there. Go get it. Okay? And now we have the benefit of sometimes using it. And you know what? This works both ways. Meaning, there will be instances where the defense attorney will do the same exact thing to me and to the exhibits that I have created. I don't want to show the jury that I'm reluctant to do that, although I would love to do that to put him at a disadvantage. A sense of fair play in the courtroom is, okay, go ahead and use my exhibit. Because if I don't, and if he doesn't, the jury's going to turn around and say, why not? What are you guys doing, playing games with each other? This is ridiculous. Let the expert go ahead and answer the question on the basis of substantive answer. Let us see what it is he's referring to in this particular enlargement, and let's move on. So why do I share this information with you? I share it with you because this comes up in every single case where now a witness has used a particular enlargement to explain something to the jury or an exhibit, and now the other side wants to use it. And even if they've gone ahead and spent a great deal of money and time and effort to create that exhibit, the attorney who made that exhibit and is now bringing it in really does not want to go ahead and share that. And if they don't share it, guess what? Now the jury's going to wonder, why not? That's not fair. That's not right. You should allow them to use it. You know, I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.